paragraph 3 says. There was an issue with regard to animals, science, potential conflict, economic development, social welfare, etc., which came up before this court in the context of the Great Indian Bustard and Lesser Florican. Now, this court passed 3 orders, which we have summarized in para 3. The first was on 19 January 21, when a 3-member expert committee was set out.
Yes.
Then this court heard various stakeholders, and it felt that it was required, given the facts and circumstances, a more extended or extensive set of consultations. So the committee then stood expanded, my lords, pursuant to the order which was passed on the 21st of March 2024, which included 7 members plus 2 special invitees. And then the best part of it was that when the expert committee submitted its reports, our court has substantially accepted the recommendations of it. Obviously, there'll be some
Divan, that was a judgment in connection with the animal which was facing extinction.
You're right.
A rare category.
Absolutely.
How can we equate those matters with this case? There's no kind of analogy can be drawn. Sorry. It's misplaced reliance on that order.
Fair enough.
Yes.
My only suggestion is that, look, there is a space and a room for expert committees. There is perhaps a space and a room for expert committees in the facts and circumstances of this case as well. Because, I mean, we are not going to take you to the voluminous documents which we have also filed and several others have filed of various expert reports, etc. So that's something for your consideration. If you consider it appropriate, please consider it. Now, the second, if we are to go down this street, then 2 sets of suggestions came, Manoj, and those came from Mr. Venugopal, they came from Mr. Chandar Uday Singh, where there are specialist bodies which are dealing with animal jurisprudence, etc. They have expertise on this subject. So they have a much wider worldview apart from, the assistance which we can there. So you may consider that in the context if we go down through that expert committee route. Now, my lords, insofar as paragraph 25E of your lordship's order or judgment of 7th of November 2025 is concerned, that's the next set of respectful submissions. So, para 6, we submit that the suo motu directions which are issued under Article 32 and 142, generally, my lords, are exercised consistent with substantive statutory provisions. That seems to be the broad principle which we get.
Mr. Venugopal also said the same thing.
So, I don't want to tarry on that.
Yes.
Now, what your lordships have covered under 25E are educational institutions, hospitals, sports complexes, and other institutions which are mentioned. And here we point out that, look, these are large campuses. So just please keep, your lordship is of course aware of it, but they are large campuses and large areas. Now, we draw attention, which your lordships have pointed out, or already noticed, that insofar as the animal birth control rules are concerned, 1119 says the dog shall be released at the same place or locality from where it was captured. Now, the question is there some amplitude for this? Obviously, there is some amplitude. And your lordship had a pertinent question to me that, look, what is the role of experts over here? But I think an example came up just a short while ago where a particular instance of a very, it seems, an aggressive dog who was continuously biting. Now, you may get, of course, your lordships don't need experts in almost every case which you do. But sometimes it may be worth having the advantage of some insights and approaches that, look, can we make out certain exceptions to situations where this rule of Rule 1119 can be departed from, etc. There may be some guidance to be provided. But I think this earlier example was a good one, I felt, at least to carve out certain exceptions and particular situations, etc. We have catalogued again in paragraph 8, which has been mentioned to the court, that the reasons and the justification for the rule appears to be both science as well as experience. So the territoriality of the animal, the fact that it's obviously designed to be sterilized as well as vaccinated, and then you will have others migrating into the territory. That's another huge problem. I find that our application also refers to the experience, which is the prevalence of rodents, etc., increases when dogs are removed from that area. So that's another factor which your lordships may just consider. Now, my lords, I'm done with that. Now I come to a next point. Another suggestion is with respect to detention and confinement of community dogs, which are picked up by municipal authorities. These are regulated by a protocol with respect to the housing of such dogs for post-operative care. Para 10. The norm for detention and confinement is generally 4 days, and when the dog is housed in a kennel. Often the dogs are caged, and the dimensions of these cages is about 12 square feet per dog, This space is acceptable for a short period during which during the dog's recuperation. However, an animal confined for any larger length of time in a small cage may amount to cruelty. Now, if your lordship has access, I mean, if it's available, the Prevention of Cruelty to Animals Act, I just want to invite attention to Section 11. And may I just invite attention to 11(1)(e), F.
Yes.
I think these may be of some treating animals with cruelty. If any person keeps or confines an animal in any cage or other receptacle which does not measure sufficiently in height, length, and breadth to permit the animal a reasonable opportunity for movement, or F, keeps for an unreasonable time any animal chained or tethered, an unreasonably short or unreasonably heavy chain or cord, or being an owner neglects to exercise or cause to be exercised reasonably a dog habitually chained, etc. So what we have is we have some statutory guidance on what could amount to cruelty. Not that I'm suggesting that there is only cruelty, but there is some statutory measure which is there of confining. Now, in that context, we make a suggestion as far as paragraph 11 is concerned, in para 11 of the note. Since the object and purpose of this Honorable Court's directions are beneficent, the directions for capturing animals may be, that's for the court to consider, staggered or suspended until feedback is received by an expert committee as suggested. The exercise of picking up dogs may not be undertaken until, now this is also something which you may consider, until a local monitoring committee is satisfied that there are adequate and appropriate veterinary facilities for conducting sterilizations and vaccination of the community dogs, and that the state local animal birth control monitoring committees established under Rule 9 of the ABC rules certifies that there are sufficient available infrastructure and arrangements for temporarily holding the dogs for recovery in post-operative care, and that the dogs are thereafter released in terms of 1119. The Honorable Court may consider an appropriate direction enabling local animal welfare groups to assist the municipal authorities by making suitable suggestions for arrangements consistent with the Prevention of Cruelty to Animals Act and the ABC rules. This Honorable Court may also consider an appropriate direction for allowing municipal authorities to work in tandem with local animal welfare groups for adoption of community dogs from streets and shelters, and to fix accountability on pet guardians for responsible guardianship, including registration, sterilization, vaccination, and non-abandonment. And this Honorable Court may consider an appropriate direction to the state and union territories to take strict action against illegal and unregistered breeders and pet shops to prevent an influx of new dogs on the street. So this is on the dogs. We have just one suggestion on cattle or two in that second section, since your lordship's order considered that. Now, your lordships, here the expression used is microchipping, and your lordships also use the expression geotagging. Now, I understand that as far as a microchip is concerned, it doesn't necessarily, it has the details and the particulars as far as the dog ownership, etc., or date of birth, but it doesn't have geographical traceability. So that's the difference, I think, between geotagging and microchipping. Now, for cattle, this Honorable Court may consider an appropriate direction for microchipping of cattle to allow for traceability fixing of abandoned cattle. Now, here, my lords, because unlike stray dogs, cattle generally our experience is, and our understanding is, that there is an owner. There is some owner as far as that, but they may have been abandoned. So this microchipping is a strategy, and it has already been deployed, my lords, in Karnataka, who is before the court, and also the corporations of Ludhiana and Chennai. So there is experience in this regard, you may consider. And finally, my lords, as far as that 2 lakhs is concerned, I think I support what Mr. Gopal Sankaranarayanan has said. However, I should mention that when we try to deposit that amount on the part of the body or organization, I appeared the registry said that there must be a specific order from the court in that regard, because we were not covered at that situation. Right. So I'm very grateful. My lords, the other point I might just mention, there's another sheet.
That's for the expert committee.
Yes, suggested remit. If your lordship goes down that street, then there is a suggested remit which may be there. I might just indicate, Manoj, that there is one more IA, and I realize that there is at an appropriate time, Mr. Zal Andyarujana will be addressing your lordships for that. It's an organization, and that is IA 330102 of 2025. 330102 of 2025. Where Mr. Andyarujana will address your lordship. No, he's addressing the court virtually. Yeah. I'm very grateful. Yeah,
Mr. Siddharth Luthra is here. Please come. You also want to make submissions? After.
Plus, I also want 1 minute.
You are all much behind. Wait. After this, Miss Nandi, then Miss Mahalakshmi Pavni.
I'll also take about.
Would
I be getting a chance today?
No, no, you are for an HI. We will hear you. Maybe tomorrow or next week sometime.
My lord, Dr. Singhvi is also online.
Yes,
My
yes.
lord will
We
accommodate.
are not closing it.
Yes.
It is continuing. Huh?
Two, three very important things.
My
No,
lords,
everyone has very important points.
this will take 5 minutes.
Sorry, Miss
but-
Pavni, will you please take your seat?
My lords, the request
No,
is
no
because
comment.
I'm suffering from respiratory
You
problems.
can leave today. We will hear you on another day. Don't worry. You can come online.
I also have 2 minutes for this.
Yes, Mr. Luthra.
My lord, I appear in two matters. I'll just give your lordship the IA numbers.
Yes, please give.
300229 of 2025.
300229.
9 of 2025. That seeks recall of certain of the directions in the 7th of November order.
And?
And 330204.
No, the first one was 300.
300229, my lord.
And now this is 330.
Lord, this is 330204. It is a challenge to the SOP. It
Of
is the
2711.
yes.
Very good.
Now, Lord, put it simply, the organization that I represent is an organization called Humane World for Animals India. It's an organization which is done work in. Kindly just note the paras of my application. That will clarify, Lord. Paras 10 to 17.
Which application?
Lord, 300229. I'll go by those paras, Lord, only. I want your lordship only to have that application, not the others.
Para number?
Lord, please look at paras 10 to 17. What, man? Yeah, I can't finish.
10 to 17.
10 to 17, Lord. This point out the work I've done in Uttarakhand with municipal corporations. I've got the.
Mr. Luthra, don't have to go
No,
through your
I'm
bona
just-
fides.
no,
Not
no,
just
no,
appearing.
no, Lord, I'm
Indicate
just-
that there is somebody
Lord,
genuine
I'm
who has
just
come here.
pointing out that the work that has been done, which has been effective in these places. So the numbers and details are there. I'm not going to repeat that. Including for government of Bhutan and overseas. Now, Lord, the issue is this. I'm not going to get into much of the details because a lot of water and other technicalities. I'm not a technical person. Our point is this. Your Lordship, by the order of 7th November 2025, have passed certain directions which we believe go beyond the ABC rules. The question really is, and at the same time, your Lordship has also said ABC rules are recognized, they have to be implemented. Now, my submission is only this, Lord. There are two coordinate benches of your Lordship's court, Lord. I put those orders in my application, R4 at page 76.
And?
Page 76 and the para 9, my lord, may just see.
And the other order is? Annexure R?
R5, page 89 at page 91. Both of these recognize that the ABC rules are the legislation on the subject.
Yes.
I'm not today. A lot is said back and forth about even anecdotal information. But there are issues on the highways. There are occasions when we drive, not personally, one has driven to Rajasthan and other places. Even Delhi airport, there are Nil guys on the street, but you're not going to cull them away. Then, in fact, the legislation took them out of the category of vermin under the Wildlife Act also, whatever. We are looking at asking your lordship not only in terms of there is a scientific basis of the ABC rules. There are expert bodies under the law. If the rules have to be tinkered with, please consider that expert body. When my lord looks at the rules, not kindly just come, it's R3, page 57 of my application. And the schedule is at page 71. Please see, this is the body which your lordship ought to consider tasking with the job if the rules need to at all be tinkered with. Page 71, my lord. Schedule 2.
Yes.
It's a constitution of a monitoring committee under rules 9.
19293.
Yes, Lord.
They're separate committees, yes.
Yes, Lord. Central Monitoring and Coordinating Committee, and it comprises of various representatives all over India. And the job is to monitor proper implementation, promote the animal birth control program, facilitate interministerial coordination, and resolve issues, matter relating to policy intervention, any other matter, etc. So that body is in place under the statute, under the rule. Now, today, it had fallen from my Lord Justice Mehta, Lord, that perhaps we need a Lalita Kumari. Lord, may I just now come to the last part of the submission? Lalita Kumari was in a domain where the question was whether 154 CRPC ought to be enforced or not. I recall because I happened to assist in that matter. Certain guidelines were given in para 120.6 in relation to rules that were framed. For example, what certain ad hoc administrative mechanism which existed. That's why your lordship intervened because there was administrative mechanisms. Now today, the question is once the rules exist, should this court, by virtue of certain directions, not all of them passed, seek to override the rules because there is no legislative vacuum? In this regard, I will place two decisions and just point out to your lordship why that should not be necessary, because it is not a case of legislative vacuum, but a case of existence of legislation here. Kindly see the 7 judges bench in P. Ramachandra. My lord has got it. 2002, 4 SCC 578. Just give copies. Madam, give copies. Paras 25, 27 and 29 and Dr. Ashwini Kumar's case.
Para 25?
25, 27 and 29.
Yes.
But para 25 says the primary function at page number 600. The primary function of judiciary is to interpret the law. It may lay down principles, guidelines, and exhibit creativity in the field left open and unoccupied by legislation. I'm not going to read beyond this.
Yes.
Now, please come to para 27. This was not in the context of prescribing periods of limitation. And your lordship, 7 judges, Lord, my lord may recall this was that case where common cause came into being. There were 2 common causes. There was Rajdev Sharma. And then this court took a view on the matter.
And Constitution of India. Yes.
27. Prescribing periods of limitation
Yes.
at the end of which the trial court would be obliged to terminate proceeding as necessary, acquit or discharge, and further making such directions applicable to all in cases in the present and for future amounts to legislation which our opinion cannot be done by judicial directives and within the arena of judicial lawmaking power available to constitutional courts. Howsoever, liberally, we may interpret Article 32, 21, 141 and 142 of the Constitutions. The dividing line is fine but perceptible. Courts can declare the law, they can interpret the law, they can remove obvious lacunae and fill the gaps, but they cannot entrench upon in the field of legislation properly meant for the legislature. Binding decisions can be used for enforcing the law, and appropriate directions may issue, including laying down of time limits and chalking out a calendar for proceedings to follow, to redeem the injustice done or for taking care of rights violated in a given set of cases. Depending on facts brought to the notice, this is permissible, but it may not, like the legislature, enact a provision akin or in lines of chapter so-and-so of the CRPC. Then Lord 29.
Yes.
Now 29, Lord, if I may just point out, 29 begins with, for the aforesaid foregoing reasons, we are of the opinion that in Common Cause 1 is modified in Common Cause 2, Rajdev, the court could not have prescribed periods of limitation beyond which trial of a criminal court cannot continue and must mandatorily be closed following an order. Now, please come to sub 3 and 4. The guidelines laid out in Antali are not exhaustive, only illustrative. They are not intended to operate as hard and fast rules or be applied like a straitjacket formula. Their applicability would depend on the fact situation. Difficult to foresee all situations. No generalization can be made. 4. It is neither advisable nor feasible nor judicially permissible to draw or prescribe an outer limit for conclusion of all criminal proceedings. Now, Lord, please come to, this is so far as this judgment is concerned. There are more paras. I won't trouble your lordship with that. Just come to the following judgment, the judgment which followed this in Dr. Ashwini Kumar, 2020, 13 SCC 585.
Paragraph.
But paragraph 13, first, at page 598. Three-judge bench. The most significant impact of the doctrine of separation of powers is seen. Not para 13. I'm sorry, I thought your lordship. Lord, 1-3, my lord, 1-3, my lord. आपको
पी
2020
कॉपी दीजिए कोर्ट मास्टर
कंजूसी कर रहे हो क्या?
नहीं दिया वो
Sorry.
रिपीट कर दिया उन्होंने
Sorry. मैम कॉपी दे दीजिएगा.
Doesn't matter, you pass on subsequent.
पास इट ऑन लेटर ऑन
Later on.
No, no, just Lord, what I, मैम जरा जल्दी कीजिएगा if you don't mind.
para 27 20
Lordship's got para 30. Ma'am, Lord,
13 or 30
1-3, my lord, 1-3
1-3,
at
yes.
page 598. Ma'am, Lord, I'll read the first sentence, Lord.
yes
And in fact, I'll just read, Lord, the most significant impact of the doctrine of separation of powers is seen and felt in terms of institutional independence of the judiciary from other organs of the state. Judiciary, in terms of personnel, the judges is independent. Judges, unlike other members of the legislature, represent no one, strictly speaking, not even the citizens. Judges are not accountable and answerable as the political executives to the legislature and elected representatives to the electorate. This independence ensures that judges perform constitutional function of safeguarding the supremacy of the constitution while exercising the power of judicial review in a fair and even-handed manner without pressure. As an interpreter, guardian and protector of the constitution, judiciary checks and curbs violations of the constitution by the government when they overstep their constitutional limits, violate the basic structure, infringe fundamental rights, or act contrary to law. Power of judicial review has been excised within its ambit, this concept of social and economic justice, yet while exercising the powers of judicial review, courts do not encroach upon the field marked by the Constitution for the legislature and the executive, as the courts examine legality and validity of the legislation or government action and not the wisdom behind the legislative measure or relative merits or demerits of governmental action. Neither does the Constitution permit the courts to direct, advise, or sermonize others in the spheres reserved for them by the Constitution, provided the legislature or the executive do not transgress their constitutional limits or statutory functions. Then, my lord, we come straight away to para number 22. That will quote P. Ramachandra Rao. I'm not going to repeat it, my
please
lord.
don't repeat that
No, I won't. Now, my lord, please come to para 26.
yes
Please come to legislature as an institution and wing of government is a microcosm of the bigger social community possessing qualities of a democratic institution in terms of composition, diversity, and accountability. Legislature uses inbuilt procedures carefully designed and adopted to bring a plenitude of representation and resources that they have access to information, skills, expertise, and knowledge of the people working within the institution and outside in the form of executive. Process and method of legislation and judicial adjudication are entirely distinct. Judicial adjudication involves applying rules of interpretation and law of precedence, and notwithstanding deep understanding, knowledge, and wisdom of an individual judge of the bench, it cannot be equated with lawmaking in a democratic society by legislators, given their wider and broader diverse polity. The Constitution states that legislature is supreme and has the final say in matters of legislation, and when it reflects on alternatives and choices with inputs from different quarters with a check in the form of democratic accountability and a further check by the courts which exercise the power of judicial review. It is not for the judges to seek to develop new all-embracing principles of law in a way that reflects the stance opinion of the individual judges when the society legislatures as a whole are unclear and substantially divided on relevant issues. Then Lord Bhim Singh is quoted. But I'll read that one sentence. In Bhim Singh, while observing that the Constitution does not strictly prohibit overlapping of functions, as this is inevitable in the modern parliamentary democracy, the Constitution prohibits exercise of functions of another branch, which result in wresting away of the regime of constitutional accountability. Now, Lord, there are paras 27 and 29 also. And I must also, in all fairness, Lord, point out to your Lordship that this court also takes a view that where it's at page para 37, Lord, I must place that in all fairness, but because this has to be also considered. However, this is not to state that the courts would not step in when required to protect fundamental rights, it is indisputable that the right to life and the right to liberty are of foremost importance in a democratic state, and therefore any form of torture would violate the right to life and is prohibited. Such action would be unconstitutional under 21 and would fail the test of non-arbitrariness under 14. Indeed, the courts have been at the forefront in protecting and safeguarding individual rights, and then what examples are given. Now, the submission I will end with is this. There is the recognition that the legislative framework has not been put into effect by the executive. It is not being implemented. But is that a reason to override the ABC rules? I leave your lordship with that thought. Grateful.
Thank you for your fairness, yes.
Yeah. I'm grateful, not your lordship, being kind to hear me and indulge me.
Yes, Mr. Kant. वैसे भी आज खत्म नहीं Yes, please.
I have two IOs, my lord. The first one is 316361 of 25. That is for impediment. And the second one is
Sorry, once again.
316361 of 25.
316.
361. Yes, my lord.
All right, we reverse it. Huh.
That's for impediment.
Okay.
And 362, my lords, is for directions.
316. 362.
362.
It's for directions.
Yes, my lords. Now, I represent, my lords, 8 students of the Faculty of Law of the Delhi University. We are a part of, my lords, the animal cell there. And we have taken certain initiatives in a section of the Delhi University, which complies of, my lords, the law faculty, the campus law center, the arts faculty, the examination block, Kannad Bhavan and Umang Bhavan. The initiatives that we have taken here are set out in my application at page 10, at para 10.
The directions application.
The first application.
Implement.
They are in both. In the first application,
Yes.
para 10. One is that in this area, we did a census, my lords, to see how many stray dogs were there.
Yes.
There were 49, my lords.
Sir.
There were 49 stray dogs in this area that I have enumerated. Then, my lords, and we started our work in November 24, not too long ago. Between then and now, we have sterilized and vaccinated 28